I don't want him to make noise when I'm in court. I don't want him to make noise while I'm in court.
My mic is on, but I don't know how to unmute it from here because I don't have a mouse.
You can be heard very clearly. I can hear you clearly. At the prosecutor's table, it's perfect.
Okay.
Well, I wouldn't go that far.
All right.
I think I'm too tall to practice in the court. No.
Okay, Mr. Bradford, if you would please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give in the matters pending before this court will be the truth and nothing but the truth?
Yes, I do.
Okay, you can put your hand down. Could you please state your true, correct, and legal name for the record?
Gary Stephen Bradford II.
And Mr. Bradford, are you also known as El Dorado Red?
Yes, sir, I am.
Okay. And Mr. Bradford, are you taking at this time or under the influence of any alcohol, drugs, or medicine?
No, sir.
And is there any medication that you take on a daily basis that you have not taken today?
No, sir.
And do you understand why you're here today?
Yes, sir.
And how old are you, sir, and how far have you gone in school?
I'm 40 years old and I graduated with a GED.
Okay. And are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you are charged with the following offenses in indictment number 13 SC or 123643? The remaining counts: participation in a criminal street gang activity and conspiracy to commit a crime, murder, and that you were found not guilty of counts 3, 4, 5, 6, and 7.
Yes, sir.
Okay. And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive another jury trial.
Yes, sir.
And have you had an opportunity to speak with your attorney, Mr. Wolf, about all the facts and circumstances surrounding this plea?
Yes, sir, I am.
Okay. And do you need any additional time to discuss the matters today with your attorney?
No, sir.
And are you satisfied with the services provided to you by Mr. Wolf?
Yes, very.
And Mr. Wolf, do you waive formal reading of the indictment?
Yes, we waive a formal reading.
And do you waive any and all defects in the indictment, including any with respect to your client's name as for this plea?
Yes, I think it came out during the trial that his stage name, he's a rapper, is El Dorado Red, but yes, any defect we waive.
Okay. And Mr. Bradford, has your attorney advised you of the minimum and maximum sentence for each of the remaining charges in the indictment you're pleading to?
Yes, sir.
And did he advise to you that the minimum is 5, the maximum is 15 years, and the participation in criminal street gang activity?
Yes, sir.
And did he explain to you that the conspiracy to commit a crime here, alleged murder, the minimum is 1 year, the maximum is 10 years?
Yes, sir.
Okay. You understand that this is a negotiated or joint plea of guilty that we are recommending your counsel and the state to the court, but the court does not have to accept or follow this recommendation and can sentence you to the maximum on each charge and run them consecutively as your honor sees fit.
Yes, sir.
And do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal court, sir?
Yes, sir.
Do you also understand that you're waiving any and all defenses by entering a plea of guilty here today?
Yes, I do.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and to not incriminate yourself, sir?
Yes, sir, I do.
Do you understand that by pleading guilty, you're giving up or waiving the following rights: the right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you are unable to afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt by the state of Georgia, and the right to appeal should you be convicted of these charges. Do you understand that you are giving up or waiving all of these rights here today by taking a plea?
Yes, sir, I understand.
And has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No, sir.
And are you aware that if you are not a United States citizen, a guilty plea will affect your immigration status and subject you to deportation, regardless of any advice given to you by your attorney or anyone else?
Yes, sir.
And is it your decision to waive these rights and enter a plea of guilty or under Alford because you believe it is in your best interest to do so?
Yes, sir, I do.
Okay. And are you aware that even though you are pleading under North Carolina versus Alford and you're not admitting your guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial, sir?
Yes, sir, I understand.
Okay. And how do you plead to count 1, which is participation in criminal street gang activity in indictment number 13 SC 123643?
I plead guilty under Alfred, sir.
And how do you plead to count 2, conspiracy to commit a crime here, murder in indictment number 13 SC 123643?
I plead guilty under Alfred.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you, sir?
Yes, sir.
And do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, sir, I do.
And do you understand that you have only 4 years from today for a felony charge to file what's called a habeas corpus petition with respect to this guilty plea?
Yes, sir.
And as your attorney, Mr. Wolf, explained to you what a habeas corpus petition is?
Yes, he has.
Okay.
Sir, do you understand the nature of the charges against you?
Yes, I do, Your Honor.
You've just heard the district attorney explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, Your Honor.
Do you understand that the court is not bound by the recommendation or the plea agreement, and I can send it to you as I deem appropriate?
Yes, Your Honor.
Although you're not admitting guilt, you have decided that it's in your best interest to plead guilty because at trial, the evidence presented against you may be strong. Is that correct?
Yes, Your Honor.
Do you freely and voluntarily enter your plea of guilty to the charges against you?
Yes, Your Honor, I do.
Is counsel satisfied that your client is competent in understanding that the plea is voluntary and that there is a sufficient fact basis for entering the plea?
Yes, there is a sufficient factual basis for the plea based upon all the evidence that was introduced at trial. The irony of the conspiratorial nature of the 2 counts to which Mr. Bradford was pleading guilty is that is activity and conspiring to commit crimes. He was acquitted of that trial, but he was also found guilty of these offenses at trial. And it is after speaking with him and after speaking with the state and after coming to the conclusion that we would like this matter to be behind us, that he has learned about the best interest plea and is wanting to move forward as negotiated here today.
And Your Honor, when Your Honor deems it appropriate, just to put on the record the factual basis for the plea, as well as the recommendation that the state and the defense are jointly recommending for the court.
Right. Are you going to recite the whole facts of the case?
Not the whole facts. No,
Right,
Your Honor.
but as you wish, you may.
Yes, Your Honor. Your Honor, had this case proceeded to trial, the state would have been able to prove beyond a reasonable doubt that on June 7th of 2012, at the Northside Women's Hospital located at 1000 Johnson Ferry Road in Sandy Springs, Georgia, here in Fulton County, that around 6:40 p.m., a 911 call was made that the victim in this case, Mr. Melvin Vernell III, was shot inside the parking garage right in front of the Women's Center, the maternity ward of the Northside Hospital. He had been shot 5 times, once in the, I believe it was the leg, arm, chest, neck, and the other arm is my understanding, Your Honor, back. Witnesses described that 2 black males, one tall, one short, were seen running from the scene right after the shots were fired. Through the investigation, which, as Your Honor is aware, took approximately a year. It was a pretty intensive investigation. They were able to determine that there was a dispute over a marijuana robbery of our victim, Mr. Vernell, of associates related to Mr. Bradford's gang, also known as the BGM gang, which is a sect of a larger national gang, the Bloods. Based upon the robbery that occurred or allegedly occurred between one of Mr. Bradford's associates and the victim in this case. At that point, it was determined through the investigation that the defendant, Mr. Bradford, and his fellow co-defendants also associated with the BGM gang conspired and did successfully complete the murder of Mr. Vernell on June 7th of 2012. It was determined through the use of phone records as well as the tracking devices that were located on the vehicle of Mr. Vernell, which was a 2012 Audi A7, that the information from one of the co-defendants, Mr. Chulpayev, which is Chulpayev, had provided the tracking information and allowed the defendant and his co-defendants to track the vehicle to Northside Hospital, where the victim was, and they ultimately were able to shoot him and cause his death. Your Honor, the evidence would show that the motive or reason for the murder of Mr. Vernell was related to the fact that Mr. Vernell had disrespected the BGM gang by stealing the marijuana. And because of that lack of respect for that gang, the crimes of murder were carried out and caused the death of Mr. Vernell. Had the case proceeded to trial, that's what the state would have been able to prove beyond a reasonable doubt, Your Honor. The negotiations between Mr. Wolf, counsel for the defendant, and the DA, Ms. Fonnie Willis, is that the defendant is to serve 7 years of probation for each count, but that to run concurrently with the special condition of probation that Mr. Bradford wear an ankle monitor for the first 2 years of his probation sentence, and the remaining 5 years to be without the ankle monitor. It's my understanding, as Your Honor is aware, that Mr. Bradford is asking for this plea to be taken under Alford. The DA, Ms. Willis, wanted to express to the court that she did not believe that a Alford plea was appropriate in this matter and objects to it, but understands that it's in the sole discretion of the court whether to accept the plea under North Carolina versus Alford, Your Honor. The DA also wanted to make sure that the court was remembered and was aware, and the record reflected that this deal is in, I guess, is a consequence of the fact that under the prior administration, a assistant district attorney who was handling the appeal, who no longer works with the office, neglected to file a response to defense counsel's lengthy motion for new trial and conceded to the court to grant the motion for new trial. And upon Your Honor's granting of the motion for a new trial, despite the state conceding, the state filed a notice of appeal of the granting of the motion for new trial. After Ms. Willis speaking with Mr. Wolf, the only appropriate action is to honor what was agreed to by the prior administration, which was the granting of the motion for new trial and the negotiated recommendation she feels is most appropriate at this time based upon all the circumstances surrounding what occurred. after the trial and during the appellate portion of Mr. Bradford's case.
If you violate your probation, I'm going to put you in prison. And if you continue in gang activity, you're just going to be right back here.
Yes, sir.
What are your plans for your life?
I'm glad that I'm able to speak to you. I'm working with Mr. Gary Davis, going back with his program with the kids, leading them away from kids involved in gang activity. And I was going to ask at the end of this to speak with your honor if I would be allowed to come back to Fulton County where I once would serve time at, to be allowed to speak with the inmates.
But that'll be up to the sheriff. I'm going to tell you a story.
If I could arrange it, I would definitely.
I'm going to tell you a story. A previous judge tried a person for a home invasion armed robbery. Because of his record, he got life without parole. I had to grant a new trial. It was obvious. I had to grant a new trial. I didn't try the case, but a distinguished judge tried the case, and we all make mistakes. And 3 weeks after he got out of jail, after serving 10 years, which was the minimum, he did another one. 3 weeks. And I want you to learn from this. And if I remember correctly, you have a special needs child. Is that correct?
Yes, sir. I do.
How many children do you have?
I have my son Blake, who you remember from coming to court, and also my fiance is pregnant again now.
All right. Well, you got to decide whether or not you're going to look at life through the windshield or the rear view mirror. Okay.
Yes, sir.
I find there is a sufficient fact basis for the charges, and also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I will accept your guilty plea and sentence as enunciated by the state and agreed to by the defense. Good luck to you. He's going to have to meet with the probation officer here. Oh, thank you, sir. All right. Good luck, Mr. Bradford. Thank you, Mr. Wolf.
Thank you, Judge.
And we should probably put on the record, I guess, when you're on an appropriate time for him to get the ankle monitor, so he's not in violation of his probation.
All right. I want the ankle monitor by the,
Judge, I want you to know, if I may, Gary's been out for several years, 40 years, has been very productive in the community, has been working with kids and driving them away from the conduct that we've talked about, and he's been on ankle monitor for the past 4 years.
are you on one now?
Yes.
Oh, perfect. Perfect.
All right. What are you going to do for a living?
Right now, I'm still in the entertainment company. I have a record deal. I'm doing the real estate, and I'm working with kids in the community. I would like to also be able to go and speak with the jails, but I was waiting for the situation and the outcome so I can.
Well, you know what prison's like.
Well, I
It's
want.
no fun.
No, it's not. And I have the experience, Your Honor, to detour my generation from making the same mistakes. So.
But I think that's good and noble, and let's do it. Let's do the right things.
Yes, sir.
All right. Thank you.
Thank you.
Your Honor, if I may, Mr. Bradford has been actually very successful in his music production. He's moved from behind the microphone to behind the production scene and has actually become quite successful, taking care of his family and his young son, as you may remember.
Thank you. Good to see you, sir.
May I say one other thing, Judge?
Yes, sir.
And regarding the factual basis, I heard the things that the state submitted to the court, and the court heard practically 30 days of evidence in this case. We agree that there's a factual basis that the state could establish to have Mr. Bradford found guilty of the 2 offenses that he just pled to, not necessarily for all the things the state said, but more importantly to me and to Mr. Bradford, who I've discussed this with, because the jury found him guilty of those two offenses at trial. That demonstrates a factual basis, whether or not we would be able to fight it again in a retrial. So there is a factual basis for sure, and thank you for allowing us to enter this.
All right, good luck to you. Good to see you, David.
Thank you.
Musa.